Hi everyone, and welcome to the Hunt and Hunt webinar on what Freedom Day means for employers. We'll just give it a moment to let some attendees in. I can see people coming. Welcome. Just give one moment to allow more people to enter. You should be seeing on your screen a presentation that says Hunt and Hunt Lawyers, and it's the primary page. If you're not seeing that, please just shoot me a message in the chat, and we'll see if we can fix that up. Okay, we'll get started. So welcome. Thank you again for joining us today for the webinar on Freedom Day. Happy Freedom Day. We finally made it, 15th of December. So just a quick few housekeeping for you to be aware of. This is being recorded and we will be sharing it after the event. The presentation will also be sent as well, so there's no need to take some notes. We will invite some questions at the end. We will like to keep them right to the end though, so we can get through the content. We just want to make it a little bit shorter today because we know everyone's busy, but so we'll be recording the questions and you can look at them later on if need be. So I'd like to introduce myself first. Sorry, I'm Sarah Capello. I'm the partner in the workplace relations team here at Hunt and Hunt, as well as in litigation. And I work with a team of lawyers to address any workplace issues. Andrew Campbell, who's a partner in our litigation team, was meant to be here today, but unfortunately couldn't attend because he got called away to court. So hopefully we'll be seeing some great webinars from him next year. But we do have today George Morani from our litigation team here. George is one of the young guns in our litigation team, and he's got a keen interest in sports law. So welcome, George. Thanks for joining us.
No worries, Sarah. Good morning. Good morning, everyone. Thank you for joining us.
Thanks, George. So here is the agenda for today. We'll be talking about, obviously, the current public health orders, which hot off the press came out last night and come into effect today. So George is going to be talking about those orders, what they are, and the effect of those public health orders. I'll be doing a little more of a focus on how they apply to the workplace and what the opening up means for employers and their obligations. And then we'll also be talking about some recent cases that have come about. So there's a really big decision that I'll be focusing upon. And then we'll finish off by just setting out our resources and then answering any questions. So I'll invite you later on to go back and view some of our previous webinars because that really gets into a lot more detail, and I'll give those links a little bit later. So passing over to George now.
Well, thank you, Sarah, and good morning, everyone. Again, thank you very much for joining us. Happy Freedom Day. And I'm looking forward to getting stuck into the details of what this public health order means for us in New South Wales. But first, I think I would power through just some of our basic legal stuff just to get you in the mind frame of what the public health order is and what it means. So the public health order is enforceable under the Public Health Act of 2010. It is a public health order as opposed to a law. So you could think of it in a way as a public health order is a law within a law, which doesn't need to be passed by both houses of Parliament, but it can be signed off by the Minister of Health, which at this stage, I believe is Brad Hazzard. And he has those authorities under the Public Health Act to put an order forward in circumstances where he thinks on reasonable grounds that there is a high risk to the public health and safety. And at this stage, I think most would agree that COVID-19 has posed that risk to society in that definition, in that threshold. Those public health orders have survived a couple of Supreme Court challenges in terms of its validity, and Sarah will explain a little bit more later on. So at this stage, we can expect that those public health orders that have just come into place yesterday are to be abided by. And as you can see, if a non-compliance occurs with those orders, then offences can include heavy fines and or in most severe cases and there could be imprisonment, although unlikely. Next slide, please. So that is the front cover of the public health order that just came into effect last night. To be honest, it was only uploaded onto the website in the midst of my sleep. So we've had to have a digest of what that looks like this morning, but that's the cover and that's what it looks like. And there you will see straight away, Brad Hazzard, meaning that it is the authority of the Minister of Health that is making these decisions on behalf of the public. Next slide. So where you want to find it, if you want to jog down this this link, legislation.newsouthwales.gov.au, and that'll take you straight away to the New South Wales legislation website. And I encourage you to use that method of looking for public health orders and information rather than relying on other non-formal means of finding information through social media pages. That's where you'll find the proper information, where you'll be able to get all that you need in relation to what this means. So if you want to get that down, that'll work, and it should take you to the page. Under that page, you will see a title called Bills. You click on Bills, and the next slide will show you that there is COVID-19 legislation. Click on the COVID-19 legislation, and then you'll find all the public health orders with respect to self-isolation, airport and transportation, movement and travel. It's all there for you to see, and that's where the most reliable source of information can come from.
Thanks, George. If you click on the link here, you'll see Jess Baldwin in our last webinar gave a great demonstration about how to specifically find them. So that's another resource you could use. Definitely.
So the Freedom Day orders, what are they? What do they mean? And how can we interpret them? Well, the first is that there are no density limits for all settings. Pretty much means places of worship, clubs, parks, households, and there are other premises and venues that I haven't mentioned because the list is inexhaustive. Those don't have density limits anymore, so you can expect to go to a bar and not have to worry about 1 2 square meter, 1 4 square meter rules anymore. That's now a thing of the past, or at least temporarily, and you can be very flexible in those settings. COVID safety plans will be optional for businesses, and I'm sure Sarah will be very adamant in telling you that although it's optional, it is still very much recommended and very much encouraged for purposes of in workplaces and following work health and safety obligations. Will be very much so a primary factor when thinking about these types of things. Check-ins for funerals as well as certain premises are still required. I think the reasons are twofold. The first reason is that generally you'll find in funerals and aged care and other areas, there is a higher prevalence of elderly aged communities and people, and there is more of a need to protect them from transmission. But also the second part as well is generally you'd find if you're at a funeral, you're mourning, you're generally hugging people and getting into contact with them. So there would be a greater need to separate yourself and reduce the risk of any transmission. Work health and safety, working from home is allowed only at the employee's discretion, and Sarah will take you through about what you should be doing if you want to be working from home, what the employer should be doing if they want to impose such a policy or a requirement. But at least for now, the government has flagged that it is entirely up to the employer's discretion about what working arrangements that means for you. Community sport, which is great for me, is permitted for all staff, spectators and participants. Effectively means you can run around with your mates or with your children, with your families. You can run around and at the park all over again and not have to worry about any social distancing or density limits. Community sport can resume, and I know I've already signed myself up for a summer comp this summer. I've gained on a little bit of kilos from all the working from home, so I'll be running again this summer, and that's great. And interestingly, and what I find more fascinating is that proof of vaccination is still required for indoor music festivals with over 1,000 people and cruises with over 100 passengers. I must say, I will flag this initially, it's not actually, or at least I haven't found it in the public health order where it says 100 passengers for cruises. I've seen the roadmap, but I haven't particularly found where it says that in the public health order. So I'd be interested to see what happens, whether there'll be an amendment or whether I've just missed it. But for now, and the public health and the roadmap definitely suggests that 1,000 people at an indoor festival, vaccinations will be required. And it's interesting because I attend Sydney FC games on a regular occasion. I'm a member, and there are no restrictions on movement, any COVID safe seating or anything like that at the stadium. So it's interesting how they're differentiating a stadium from an indoor festival when, in my opinion, it's equally likely to transmit the virus. Next slide. So no masks, which is a bit of a bugger for me because I love rocking my South Sydney Rabbitohs mask. But nonetheless, if you're intending on catching public transport or planes at airports or if you are in front of someone who is not fully vaccinated at a hospitality venue, you will still need to be wearing your mask, so you can still be funky with those as much as you like. Quarantine for vaccinated international travels is constantly changing. Before, the roadmap suggested that you would only need to isolate until you get a negative result, but it's flagged now in the public health order that, in fact, what you would need to do is you need to isolate for 72 hours, do PCR testing until you get a negative result, and then after 6 days, you would also need to do a further testing to be negative. And within that whole 7-day period, you're not allowed to go to any high-risk venues to potentially cause any transmission. International travellers who are not fully vaccinated will still need to be quarantining on arrival. Now, this is exciting for someone like me who was intending to travel next year, but it looks like there is still going to be that barrier in circumstances where the government might be able to let you out to wherever you want to go, but they might cap the arrivals, so it might be a little bit hard to get back in if you choose to make any overseas travel sometime within the next year, or at least until these public health orders are still into effect. Next slide. So self-isolation requirements are pretty much unchanged from the 4th of December. You are to self-isolate until you receive a negative result. If you are in contact with someone who has received who is fully vaccinated, should receive both doses of the vaccine, you have to quarantine for 7 days. I believe the idea is that if someone is fully vaccinated, that they are less likely of transmitting the virus and it's less severe. Whereas if you're unvaccinated, there is a 14-day waiting period in isolation. But in saying that, if there are circumstances, for example, you need urgent care or you need to escape from risk of harm, please do so in order to protect yourself from those emergency situations. And it's very much encouraged that you do find the support you need if that ever comes into your households. Next slide. Next slide. So the effect of these public health orders, well, they're great in terms of freedoms, but there are still barriers. And the reason I say that is there are some circumstances where there can still be restrictions and toughening additions in terms of your freedoms. The reason I say that is because the public health orders that we've just gone through now are only the basic standard of rules that apply on the state effectively. So companies and organizations are still within the option and many have chosen to take the option of continuing their tougher restrictions on things like entry into workplaces, entries into premises, into places of worships. And the reason why they do that is because they want to keep the environment COVID safe. They want to follow their work health and safety obligations. And Sarah will tell you as to why that is important, particularly in an employment and workplace point of view later on. But at least until now, it is still very available for a company and an organization to require you to reduce your vaccination, to require you to wear a mask, require you to be social distancing from another person. And the government is pretty much signaled that they're not going to intervene in circumstances where someone has implemented a policy and a procedure to make that happen. And there are complexities about that, which Sarah will explain a little bit later on. So this is the part where I will introduce myself as a sports lawyer and someone who has a keen interest in sports law. A little bit about me is I'm on the judiciary in the Canterbury District Soccer Football Association disciplinary tribunal, and I'm the chair of that tribunal. So I hear matters about judiciary in my local area of 15,000 football players. Our firm is also on the National Sports Tribunal Legal Assistance Panel, when that provides legal assistance for participants who find themselves in a situation where they need a lawyer to assist them on the tribunal. We are very capable and able to handle those when they come through our ranks. But the reason I'm focusing on these case studies in a sports law context is to give you a bit of a context about why and how these public health orders are only a bare minimum, and how other organisations, particularly in this instance, sporting entities, can make additional restrictions. For example, the NRL CEO has flagged that if you're a player in Queensland or Victoria, you won't be able to train or play with your team. The reason for that is for player safety, and that they have flagged. So that will cause problems for many NRL players who are residing in either Victoria or Queensland. I'm not sure why New South Wales is part of the picture. I imagine there must be something going on in the inside, but for at least at this stage, it's only Victoria and Queensland. And the side effect of that, or the consequence, if you like, is that there are clubs, for example, Canterbury Bankstown Bulldogs, who have implemented a vaccination policy, and that vaccination policy says that you need to be double dose vaccinated in order to play with the club in the NRL season. Now that's come with some resistance, and particularly our player John Asiata, his $4 million contract was torn up by the club for reasons that he refused to take the vaccination, and the club implemented a policy requiring it. So they pretty much went up their own ways. And I mean, if you're asking for my personal opinion, I don't think that's particularly a bad outcome for John, because if I were him, I really wouldn't want to play for the Canterbury Bankstown Bulldogs anyway. I'd play for the Rabbitohs. Anyway, moving on. Sorry, moving on. That's it. So just in relation to, very quickly, our COVID safety plan, as I said, they're no longer required, but they're still recommended. They're still recommended in all environments for sporting clubs, workplaces, bars, clubs, and all those types of venues of which attract larger crowds of people. The reason being is because they want to create an environment where they could stay open for as long as possible with as minimal transmission as possible as well. So that's the idea of it. And although it's not required by the public health order, it's still a very good way of keeping track of who's coming in and who's coming out and who could potentially be causing any transmission. And it will notify you as soon as possible if someone has got in contact with someone, so you can take the appropriate measures in the shortest available time to make those policy changes and to make those cleaning requirements that you need to do as well. So the focus I'll be talking about now is exercise, recreation, and how sporting clubs, being my niche, how that can open in a COVID safe way. And many clubs have contacted me and asking how in which they can make things work and keep their club open, keep their players on the pitch, but at the same time minimalising transmission of the virus. Reason being, it's a little bit difficult based on the sporting code. If you're a tennis player and you're standing on opposite sides of the field, it's much easier to govern, whereas if you're an NRL player and bodily fluids are being exchanged with every tackle, it's a lot harder. But some of the things I've come up with that a club can do to ensure that it is operating in a COVID-safe way is implementing those COVID marshals at those fields, telling people to social distance, asking people to scan their QR codes and to check into those places. Separating seats. I know there's this particular club that I work for, and they pull the ropes. They're a suburban local sport football club. What they do is they pull the ropes maybe 3 meters back from the field so that the spectators and the players are very far apart. And obviously, I know we've been seeing it for 18 months, or signs everywhere about hygiene and wearing face masks and hand sanitizers, but it's still a good idea. And it might give people constant reminders about what they need to do to keep themselves healthy. Next slide. Now, on the reverse end of the spectrum for players, some things that you could do to ensure that you can get on the field, do what you want to do what you love, but also try and stay as safe as possible. That includes taking up the option, or if it's not there, to ask for the option of a check-in, to make sure that you know what's around you, where you're going, and what circumstances of which you're participating in your sport. And I know this is annoying, particularly for me, but come dressed to the games. I mean, no one loves it better than I do. I rock up in thongs and shorts to a game and get changed on the spot, but get changed at home. That way, there's less likely for you to be in contact with people. You're already game ready, and it's always easier leaving the field as well. And bring in your own water bottle, your towel, and your hand sanitizer. I mean, I know in my club, we have our coach who brings an esky full of water and beers for after the game, but it's probably put on hold now because of what's going on currently in New South Wales. So just try to avoid that as much as you can. No shaking hands or celebrating goals and points. I know I like to think of myself sometimes as Cristiano Ronaldo doing fancy celebrations, but in many occasions, if you're celebrating a point, in tennis, it's not going to really so much matter because, I mean, with all due respect to tennis fans out there, you're pretty much celebrating with yourself if you win a point. But in NRL, in football, if you score a goal, jumping on each other it's try to keep that as minimal as possible. I know it sounds silly. I know because we're already tackling each other, we're already exchanging body fluids, but the idea is to minimize contact and to give yourself the best opportunity to be safe and leaving the game. And the last thing is to try and break up training sessions. And many of your coaches might actually tell you this is actually good for your performance, to break up into smaller groups in different environments. That way, not only you're getting into less contact with people, but you're also focusing on the smaller things in your game. I know in football, I was always told to get into small groups in tight environments, and that way you can improve in your core skills that way. So it might actually work for you in a positive way. Who knows? But it's an idea nonetheless. Next slide. So public health orders are here to stay. And the reason why I say that is variants are continuing to emerge, particularly in lower socioeconomic countries where vaccination rates are still quite poor. For example, the most recent one is Omicron, and the government is still right now trying to assess and understand what it means, what its resistance is to vaccinations. And I think last night or 2 nights ago, the New South Wales Health Minister flagged that he wanted the time for booster shots to halve from 6 months to 3 months, meaning that he wants the 3 months requirement for second dose or third dose vaccinations to start happening after you've received your second. So that time is already halved, flagging the need for booster shots to happen earlier. And I think for as long as booster shots are happening and for as long as variants are emerging from the virus, there will be public health orders in place. So I don't think we're quite turned the corner there yet, but at least for now, and I think looking into 2022, there'll definitely be a role for public health orders. It will probably still change, and we will do our best to inform you as soon as something changes and let you know exactly what they are and what they mean for you. So, sorry, next slide.
That's it.
Oh. So look, on that basis, if you are someone who runs a sports organization, or you're a player, you're an athlete, you're someone who's formed part of a committee or a sporting organization or even a general corporation, we get plenty of inquiries from people who are concerned about how they want to open up. I understand you're already tight funded in terms of costs, and I understand that you're already restricted in terms of your volunteers and making the organisation work. But if you do need any advice or any legal assistance in terms of how you can make sure that your sporting organisation can operate in a COVID-safe way, or if you are a player who wants to make sure that you're able to participate in your sporting code, be it a vaccination issue or another issue, please do feel free to come and contact me. I know how it works in the industry, having played for many years in a professional level and now in a community level. And we do have these issues on the judiciary as well that I'm currently sitting at. So please contact me if you have any advice. But for now, and moving on to our expert partner, Sarah Capella, she'll tell you a little bit more about those effects of the public health orders and particularly how that works in the workplace and what you need to think about in terms of your work health and safety obligations. So passing on to you, Sarah.
Thank you, George. So as George outlined, the public health orders, they only came about last night. We were given some indication through the roadmap what they might look at. So we did develop an idea of that prior, but they've just been released and we've gone through them in detail. Essentially, the public health orders are silent on the return to work. And you might recall the earlier versions set out some obligations, and that was with respect to employers not requiring vaccinated people to come to the office if it was not reasonably practical to do so, and also then putting an extra lay on those unvaccinated persons to not attend the office if they were not vaccinated. So now that they're silent, it really comes down to the employer's discretion as to whether they should bring them back or not. But even though there's a relaxing of the government restrictions, there is still very much a duty of care that remains. And that duty of care is really extended to both employees and any other persons who are attending the premises. So that includes, your contractors, your suppliers, it includes your customers, or anyone who's coming on there. You have an obligation as the employer to make sure that they're kept safe. And so I'm going to talk a little bit more about this later, and it's really in the context of a case that's come about just recently. And it's quite convenient that it's come about now so we can talk about it also in the context of the new public health orders. So we'll be putting a bit of focus on that case because there's a lot of insight into how things should work. Now, I'm going to be using again a few slides from my previous webinars, and it's not because I'm lazy, although these things do take some time, but it's also because they're still very relevant, and it's good to kind of go back and look to see, what we were talking about a few months ago and how they apply to today. So this is one of those slides, and this was the webinar I did with Dave Thompson from our Melbourne office, and he spoke about the control measures that can be put into place. And these control measures need to be really considered on a case-by-case basis. And you have to look at the specifics of the site, and then you have to conduct a risk assessment. Now, we can obviously help with the risk assessment, or you can get a more practical approach in bringing in a work health and safety consultant. We have some relationship with some great consultants, so if you need a referral, then please let us know. It's really important to come in and make sure that you're aware of what your obligations are, which is what I will talk about, but then how you can actually implement some measures to reduce any risk that you have to your employees. Because number one, you want to be compliant, but more than that, you want to make sure that your staff and everybody who's connected to the business is going to be safe. Now, this is, it might be a little bit controversial to say this, but I'm not expressing any personal opinions about this. This is actually, this statement about vaccinations being the most effective control measure is something that came out of this case that I'll discuss, and that's the tongue twister. It's CFMMEU against Mount Arthur Coal. It was a full bench of the federal court, the Fair Work Commission rather, that was decided just very recently. And in the case, it was quite an interesting judgment to read. I really enjoyed reading through it. They relied upon some medical experts' reports, which really said that, and it was actually determined in the judgment that vaccination is the most effective control measure that a business can implement for a couple of reasons. And one was that not only does it reduce the risk of transmission, because it was determined by the experts that it's less likely to be transmitted, even though it can be, it's less likely to be transmitted. But more than that, it actually reduces the infectious period as well. So when you have things like PPE, which are also effective in trying to reduce transmission, PPE doesn't do anything to protect once you actually have been diagnosed with COVID. And this is why they determined that vaccination was the most effective control measure. So we're seeing a lot of our clients thinking about what they need to do in order to make sure that they can comply and keep their employees safe. And I've just put a few examples here about what some businesses are doing and the kind of policies that we're advising on and helping to draft and to implement. And that's no jab, no office, no jab, no job, no jab, no entry to premises, and a more targeted approach. Now, the no jab, no entry to premises is actually the approach that they took in the Mount Arthur Coal case. And Mount Arthur are actually a subsidiary of BHP. And they were actually commended by the Fair Work Commission for doing a really good job in making sure that they responded in an appropriate manner to the COVID risks. So BHP had actually gone to quite some lengths. They had a vaccination clinic which was on site for their employees. They had a hotline that was available. They really rolled out a lot of different measures to try and reduce the risk to their staff. But where they essentially failed, I'm giving away the ending to the decision, is they failed in implementing a mandatory policy, but it was not, the reason really came down to consultation. So I'll talk about that in a moment. But I did want to acknowledge, however, that the Fair Work Commission said that they sympathised for employers, and they recognise that employers are really faced with a really difficult, they're really in a difficult position at the moment because of the ever-changing and the dynamic environment. So when the decision was actually heard in the hearing, the Omicron variant actually wasn't present in Australia. It wasn't really an issue. But by the time, in the time period where the decision was actually handed down, it was an issue. And so the decision actually mentions it. And they kind of gave reference to the really fast pace and the evolution. And that's relevant for you, because as business owners, you need to be constantly looking at the climate and the environment to see, what do I need to do? I don't know where the numbers are up today, I haven't checked, but there has been a gradual increase and leading up to the Christmas period, and you want to make sure that you're responding appropriately to that. And that's things like, should you be having Christmas parties? Should you be having get-togethers, gatherings when there's a higher risk in Sydney? Now, I'm not a huge fan of putting large chunks of text on presentations, but I've actually done it here because I just wanted to kind of mention really the basis upon which you can mandate vaccinations in the workplace if you're not governed by a public health order. So just a quick refresher, there are some public health orders that mandate vaccinations for some industries, and they're like the aged care industry, the disability services. So if you're in that industry, you're well and truly aware by now that a mandatory vaccination order will apply. But if you're not sure, and we are still actually giving advice to some organisations which are kind of on the periphery of those industries, whether it does or doesn't apply, but just make sure you're checking first. But what I'm talking about today is where a public health order doesn't apply. And in that case, how do you mandate vaccinations in that context? And the answer is, and I talk about this a lot in the other webinars, and if you don't know by now, it is by giving a lawful and reasonable direction to your employees, and then that forms the basis upon which they are required to then be vaccinated, if that is what the direction is. Whether that direction is reasonable or not is a very different question, and one that we often have to give advice on and we have to consider. And this is what really failed in this case, that it was not a reasonable direction. So looking to the reasons why, and I've already given a heads up as to what happened, but they failed with their consultation obligations, and the court decided that it was not a lawful and reasonable direction, therefore the mandatory vaccination policy could not apply. In a practical sense, what that meant for the business is that they had actually not allowed some employees who were unvaccinated to attend the premises. So they had given undertakings that they would have to pay those employees for the period where they were not attending and actually not performing any work. So there's a real cost to the business. But beyond that too, there's obviously some risk factors that come to play, because then what's the next step? And I'll talk about that in a minute. But the answer to, if you do decide that you want to implement some policy, whatever that's going to look like, as I mentioned, no jab, no job, no jab, no premises, however you want it to look, what you have to do is essential. In this case, really is clear on that, is consult. Consult with your employees, consult with the people who this is going to be affected by. And if you don't, then you might find yourself in the same position that the Mount Arthur coal mine find themselves in, where they are not able to implement this. Now, just the source of this consultation obligation in this context was in the Work Health and Safety Act. And if you go to those sections in the Act, it actually sets out very clearly what those obligations are. There are also a number of different sources which you should consider, which might be relevant to your business. And they are things like the Irrelevant Award or an EBA, because sometimes there's obligations under those as well that you need to comply with. Now, I'm going to give a little bit more examples about what you should do in terms of your consultation. Now, firstly, do it prior to implementation. I mean, that should be kind of common sense, because if you're not doing it, if you're doing it after implementation, then that's really just box ticking, and you're not actually undergoing a proper consultation process. It's really important that the consultation has a lot of substance to it, and it's not just done it's not just done to kind of tick a box, as I said. It has to be engaging. You have to allow people an opportunity to express their views. And the case talks about this, and here are some of the things that they mentioned. It's a responsibility to give those consulted an opportunity to be heard and to express their views. So it needs to be real, not merely formal, and not really just an exercise that you're undertaking in order to comply with the legislation. It has to be a real consultation process. It should be designed to assist management in making the decision. And this is why it has to be done before the decision is made. It has to vary according to the nature and circumstances. So what I took that to mean was you have to look at the context of the workplace. If you have a workplace where people are not sat at their computers all day and they're hands-on, a little bit more hands-on, then you can consult with them in person. You go up to them and you speak. You have toolbox meetings. You engage in a way which is more familiar with how they operate. If you have like a law firm where we're sat behind our computers all day reading emails, then maybe an email is appropriate to invite feedback in electronic form. So there's no hard rule, but think about how it's going to apply and how your employees can actually give that genuine feedback. Now, consultation is not a right of veto. So it's not the case when somebody says, I don't agree with this, I don't want you to implement it, that you have to say, okay, I won't do it. That's not what it's designed for. It's designed for genuine discussion about how it might affect people. There's also no requirement to reach an agreement. But really, what I want you to take away from this is that the stage of the decision making and where the consultation applies is incredibly relevant, because this is what happened in this case. So it can't be an afterthought. And this might be a little bit semantic, but what the wording of how you consult as well is quite important as well. So you might send a draft policy and invite feedback on that draft policy as the second stage. But about how you word that is quite important. Instead of saying, this is what we're going to do, tell me what you think, you would say, we're thinking of doing this, what do you think? I know it doesn't sound like a big difference, but it actually is quite important about how it actually will be perceived. Now, what happened? So as I said, with Mount Arthur, they determined that it was not a reasonable and lawful direction, in which case it was not a requirement for people to be vaccinated on site. But the Fair Work Commission did say that if they had actually undergone the proper consultation process, they probably would have said it was a lawful and reasonable direction. And they were giving, I guess, some insight into the fact that it probably should be implemented, but go through the proper channels. The procedure is very important. And so the Commission actually did invite some submissions from both of the parties about, what do you think should be done? And the applicant, which was the union, said they made submissions say, let's just wait and see. Let's wait and see what happens in terms of whether the virus there's another outbreak. Let's see what happens, and then we'll respond and we'll see how bad it's going to be. Commission did not like that submission. They said it was not appropriate and it wouldn't comply with the work health and safety obligations, and it shouldn't be an exercise in waiting and see. So the takeaway from that is you need to act. You can't sit back and wait and see whether it comes to your workplace or not. You act beforehand. I hope I'm not scaring anyone on a Wednesday morning in the week before Christmas, but it's really important that you don't put your head in the sand, that you actually turn your mind to this stuff. Now, how to go about doing it? I'm going to be really quick here, because I've actually talked about this in quite a lot of detail in the other webinars, but you want to think about how you want to approach it in your workplace and how it's going to work for you. You're going to go through your consultation process. You're going to have a written policy, because it's not essential. And as George talked about that case of the Bulldogs, they didn't have a written policy. But in my view, I think it is best practice. That's just my personal view. But you want to make sure that it's flexible. You want to implement it consistently. It can't be that it applies to Mary in accounting, but it doesn't apply to Bob in sales because he's a great performer. That you can't do that. That's not appropriate. You have to make sure that you're applying it consistently. And then also you want to make sure that if somebody is not following that policy, that you're taking the proper steps in order to make sure that the disciplinary action or the termination is done properly. Because if you're not, then you're going to be exposing yourself to a claim, and we're seeing those claims come up often. Now, there hasn't been any Fair Work decisions just yet, as far as I'm aware, about any unfair dismissal applications specifically relating to COVID vaccinations. There has been some about flu vaccinations, which talk about COVID vaccinations, but Joey Tass, who's a senior associate in my team, and I are working on one at the moment relating to COVID vaccinations. And so it's going to be a really short period of time before we're going to see these decisions, if not Joey and the decision Joey and I are working on, but other businesses as well. Now, really quick point here, consider your privacy requirements as well. In the Mount Arthur coal case, they did touch upon it, but they actually didn't give a decision about how it would fall, whether it actually invoked certain privacy obligations. It's really disappointing because people want answers as to whether they have to get consent prior. My recommendation, which I talked about in my other webinar, is get the consent from your employees before you're actually getting their vaccination status and holding that record. People have different views on that, but again, the Commission said that they didn't need to actually answer that question, which was, as I said, disappointing for us who need that guidance. Now, that's dealing with the vaccination policies. Now, other things that we're looking at now as we're getting back to business is getting employees back into the office. As I said earlier, it's at the employer's discretion, and you can bring everyone back in. Whether you should or you shouldn't depends upon whether you comply with your work health and safety obligations. If you think that it's reasonable to get everybody back in and it's safe to do so in a safe manner, you issue a reasonable and lawful direction. If somebody fails to abide by that, then that is a basis for termination. Then you can proceed down the termination path. Now, a question we're getting from a lot of clients is, What happens if an employee asks me if they can work from home? Do I have to allow them because they have been working from home for a couple of months? The answer is no, you don't have to allow them. But if they make a formal request under Section 65 of the Fair Work Act for flexible working arrangements, you do need to respond within 21 days. So just be alive to whether somebody's just saying, hey, can I work from home, versus a proper request that's being made. Now, if they are making that request, you need to look at the criteria, which is under Section 65 of the Fair Work Act. And if they tick those boxes, then you might have to actually grant the request, but you can refuse on business grounds, but you do have to turn your mind to this, because if you don't, then you'd be in breach of the Fair Work Act. So take some time to have a look at that and go through the specifics of the employee if and when that request is made. Now, I'm going really fast through this, so if you've got any questions, and as George said, you're most welcome to get in touch with me after and raise any questions, because we're really here to help through this. It's a really uncertain time, and we want to be a resource available to you to help guide you through this and not actually be exposed to any fines. A really quick point that I just wanted to touch upon here is the challenges to the public health order. And I actually had a question that came up while George was speaking about the constitutional validity of the public health orders and the reasonableness. So hopefully I've answered the question of reasonableness. It really depends upon the circumstances. It depends upon the procedure you follow. It depends even on the specific employee. It goes down that far into the specific employee as to whether it's reasonable or not. And that's why you have to get the right advice and go through that process before you actually make the decisions to do these things. But with the challenges to the public health orders, we've recently done an article outlining all of the challenges. So far, all of them have failed. The most recent one, there was in New South Wales, the court actually imposed a cost order against the applicant, and has also reprimanded the solicitors who were involved in that case. In some of the cases, not that specific case. And so we're not seeing any success in terms of whether they're going to be challenges and they're still in force. And I would be very surprised if the court is actually going to determine that they're invalid. The bodily integrity argument has been repeatedly rejected. So, that argument actually doesn't have any weight from what we've seen from the court judgments. But they're interesting to follow, so by all means, check out our article and follow along in the media. Now, some resources that are available to you to help you through this time. As I've mentioned repeatedly, we've done a webinar. If you haven't gotten on, we've done a few other webinars. So you can access them through our YouTube channel. And I'll go through a lot of more detail about the process of termination and implementing policies, which you can go through. And of course, we also have some articles through our website. That's just an example of some that we have. There's many more. Another really great resource that we have available to our clients and also to anybody who wants to get in touch with me is a checklist we have where you can go through and turn your mind to certain relevant factors that you want to consider when getting back to business. And that's really just to give you a bit of a guide so you know the kind of things that you need to be looking at. So get in touch with me if you'd like a copy of that and we can have a chat about it. Sorry I rushed through that, but I know everyone's very busy. So if you have any questions, then there's our contact details. George, as I said earlier, is a really young gun, very great lawyer in our litigation team and is really keen to help. He's a great person to talk to. Much more interesting than me. I've never been a professional athlete in my life.
Come on, give yourself credit.
So get in touch with us and we'll have a chat by email or give us a call. So if there's any questions, I can see that there are questions.
Just got one, yeah.
The question is, are we sending this recording to attendees? Yes, we will. We'll put it up on our YouTube channel and you'll be able to access that. Get in touch with us also if you've got any questions. We'll be happy to answer them. But as I said, it's just about being sensible. And as I always say too with our clients, have conversations with your employees and speak to them about how these things will operate. It's surprising how often, a conversation can actually solve a problem than actually going through a more formal approach. But then, of course, you need to turn your mind to that. So I'm hoping we've been a good resource and we've given a good outline of what the orders are. So thank you for attending today, and we wish everyone a great Christmas and a nice New Year's period. Everyone, hopefully they stay safe, and we'll see you again next year where we'll be doing a lot of other exciting webinars that we'll have coming up, and we'll obviously tell you about that. So thank you very much, George.
Thank you. Merry Christmas, everyone. Have a very great new year and hopefully a very prosperous one in 2022 as well.
Thanks, everyone.
Thank you.